disability, and hence our prosecution will become null and void, Your Excellencies. Again, we point, Your Excellencies, to the very recent case decided by the International Criminal Tribunal for the former Yugoslavia, the case of Prosecutor versus Nikolic Dragan, decided in October 1, 2002. In that case, Your Excellencies, the International Criminal Tribunal found that there is no obligation under international law for domestic courts to dispossess itself of its jurisdiction when it is found that the person was abducted from third states. Your Excellencies, the International Criminal Tribunal...
That is a very major difference. You just said International Criminal Tribunal.
Yes, Your Excellency.
All people who are members of armed forces.
Yes, sir.
Who were accused of genocide in their respective states.
Yes.
Am I correct?
Yes, Your Excellency.
Nazis in the case of Nuremberg.
Yes.
And these gentlemen before the International Criminal Tribunal.
Yes, Your Excellency.
Miss Tbilisi didn't kill anyone. Did she kill anyone?
No, Your Excellency.
She didn't kill anyone. She didn't maim anyone. She merely exercised her right of free speech. The cases you cite before us are as relevant to the facts of your case as cheese is to chalk. Got no relevance. Do you agree that they are not relevant?
We beg to, Your Excellency, on the factual circumstances, they may not be relevant, but on the basis of the principles laid down by the International Criminal Tribunal for the former Yugoslavia, there are precisely in point, Your Excellency. Your Excellencies, the court, the International Criminal Tribunal...
Can I interrupt you now, just now? Your co-agent says that there is no strong customary international law regarding secession, support of national liberation movements, because there is no consistent state practice. As far as the domestic judicial decisions regarding the abduction, and as not only the issue of abduction, but the issue of the invocation of the protective principle is concerned, there seems to be somewhat inconsistent state practice. They are conflicting. I'm sure they will cite the conflicting judicial decisions. So, following on your co-agent's submission about customary international law regarding secession, support of national liberation movements, how can you say that there is a strong established customary international law in the area of abduction as well as the exercise of protective principle?
Thank you very much, Your Excellency, for pointing out that very important question. Thank you very much for your...
Time is extended by 5 minutes.
Thank you very much, Your Excellency, for your time and indulgence. Your Excellency, the function of the international courts, Your Excellencies, are to apply international norms. And when the International Criminal Tribunal, Your Excellency, for the former Yugoslavia, laid down, found, what it did, Your Excellency, was survey the jurisprudence across all jurisdictions. And it found out, Your Excellency, that there is no norm under international law directing or ordering the local courts to dispossess itself of its jurisdiction when the accused was abducted. So, Your Excellency, what the court did...
That is taking the principle and standing it on its head. Don't you agree? Because you're there, they were hunting for criminals who had committed genocide. And the principle in those cases, the municipal principle which was recognized, or rather the principle of municipal law which was given recognition is, that had they been caught in their own jurisdiction, they could have been tried there.
Your Excellencies...
And that is the basis on which the International Tribunal assumed jurisdiction, on reciprocity. Because the municipal court could try them, so we can.
Your Excellencies...
You are taking that principle and standing it on its head.
Your Excellencies...
Aren't you doing that?
We beg to disagree, Your Excellencies. What the International Criminal Tribunal did was survey all the cases involving abduction. Not only cases where the accused was charged with genocide or war crimes.
Assuming, and to use your own phrase, but not conceding.
Yes, Your Excellency.
But not conceding that what the International Criminal Tribunal said is true. And the learned chief judge has already pointed out the important contextual differences. But assuming that is true, is the decision of the International Criminal Tribunal binding on this court?
Certainly not, Your Excellencies. However, we note that under Article 38, Paragraph 1, Subparagraph D of the statute of this court, Your Excellencies, decisions of tribunals are subsidiary means of determining the content of international
In
law.
other words, we can have resort to them as persuasive authority.
Certainly, Your
But
Excellency.
we are left unpersuaded because you are citing to us cases which involve genocide.
Again, Your Excellency, may I
and you
clarify?
have before us a case which involves the breach of a statute which truncates, seriously truncates freedom of speech.
Your Excellencies, we seek clarification, Your Excellencies, in that what the International Criminal Tribunal did was survey all cases, not only those including genocide, not only those including war crimes, crimes against humanity, or even aggression, Your Excellencies, but all cases, even municipal crimes, Your Excellencies. And there it found out that there is no existing state practice and concurrent opinio juris that the state will be dispossessed of its jurisdiction over an abducted person.
But if there is state practice which would amount to authorizing or permitting abductions, you know, what is prohibited is not necessarily what is permitted, and what is permitted is not what is necessarily prohibited. I think it goes back as early as the classic Lotus decision of the predecessor court, 1927 PCIJ decision.
Yes, Your Excellency. Certainly, Your Excellency. However, Your Excellency, thank you for pointing out the case of Lotus. In the case of Lotus, the PCIJ laid down the so-called Lotus principle. The Lotus principle, Your Excellency, is that when a state acts, it is presumed to be valid under international law unless there is an express prohibition of law under international law. And here, Your Excellency, we note, Your Excellency, that there is a general prohibition on abduction as laid down in the Universal Declaration of Human Rights. However, Your Excellency, there is a coexisting customary norm of international law, which is male captus bene detentus, which is, Your Excellency, that we must make a separation between the legality.
Can I interrupt you right there? You have not specifically answered the question of analogy with customary international law regarding support for national liberation movement, secession, and the MELA, this rule, which is a stronger customary international law. Aren't there equally inconsistent state practice, taking into account the asylum case for Colombia versus Peru? You know, there is no consistent state practice, and the ICJ said. So in 30 seconds, you try to make an analogy with the two.
Your Excellency, in that respect, Your Excellency, may I first make reference to the case of North Sea Continental Shelf decided by this court. In paragraph 73 of that decision made by this court, it was held that state practice must be virtually uniform and widespread, Your Excellency.
Exactly. There is no virtually uniform state practice regarding abductions, etc. Because there are conflicting US versus Alvarez matching versus United States Supreme Court with the South African state versus Iran.
Thank you very much, Your Excellencies. Your Excellencies, the cases decided by the United States, Your Excellencies, have been internationally condemned. Your Excellencies, we refer the attention of this court to the opinions of the most highly qualified publicists in our generation. We have Mr. Brownlee, we have the ex-president of this very court, Your Excellency, Madam Rosalind Higgins, as well as Professor T.J. Harris, the one they brought here, Your Excellency. All of them are in unison in saying that, Your Excellencies, that the decisions, Your Excellencies, of that male captus, Your Excellencies,
may be publicists, right?
Yes, Your Excellency.
Publicists and the judicial decisions of municipal law, which is the higher rank according to the ICJ section.
Your Excellencies, according to the ICJ